Professor Holland, but did I make sure I got the faculty? I've got Professor V and Professor Snyder. Okay, so it's not a head-to-head debate today. This was just a reminder slide for me to introduce both of our speakers. So Professor Josh Blackman is an associate professor of law at South Texas College of Law in Houston. He specializes in constitutional law, SCOTUS, and the intersection of law and technology. And he's also an adjunct scholar at the Cato Institute. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in law and policy, so congratulations on that.
Thank you.
And he is also the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. So
you should all play.
Yeah, so if your fantasy football draft didn't go so hot, check that out. You can also hit up his blog at joshblackman.com. He leads the cutting edge of legal analytics as Director of Judicial Research at Lex Predict. He has also twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's written 2 books, one entitled Unprecedented, The Constitutional Challenge to Obamacare, and the other Unraveled, Obamacare, Religious Liberty, and Executive Power, in 2013 and 2016, respectfully. He's also the author of over 3 dozen law review articles. God bless you, I can't even get one correct out. And his commentary has appeared in the New York Times, Wall Street, Washington Post, USA Today, LA Times, and other publications. 43, I counted on the list. He presents over 50 times a year. I got tired of counting after 50, so I just gave up. Math is hard, so that's why we came to law school. So I know his calendar is very full, and so we are very thankful for your time to come here today. But more to the point, Professor Blackman is the attorney for Cody Wilson, who posted the files online to create the 3D printed guns, which is what we'll be discussing today. And also on our panel is our own Professor Holland. So after graduating from law school, he spent 2 years as a judicial clerk at the United States Courts of Appeals for the Second Circuit in New York. We're glad you found your way to Texas. He then joined Washington, D.C. offices of Jones, Day, Reeves, and Pogg, and worked primarily on appellate cases before the U.S. Supreme Court and federal courts of appeals, as well as the international arbitration before the World Bank. So not to brag on our school, but we've really got some great professors. If you haven't had the opportunity to sit in their offices and kind of rely on that expertise, you're missing out. He's also a diehard Patriots, Red Sox, and Celtics fan, but don't keep that against him. And of course, he is known for being one of our beloved con law professors and BFFs with Professor V. So if you have a chance to bid on one of their joint events during the fellowship auctions, they are certainly interesting to go to hear them debate things amongst themselves. His scholarship has focused on technology, constitutional theory, especially privacy and the First Amendment, and intellectual property. Also issues of national security. So Professor Holland's expertise certainly made him the perfect fit for our discussion today. So thank you, Professor Holland, for your time as well. And just a few bits of housekeeping. So Professor Blackman will speak for 25 minutes, kind of give us the background and the debrief of the current events related to the issue. Professor Holland will do a 15-minute follow-up commentary, and then we hope to answer open the floor for Q&As for about 10 minutes. So just keep in mind, no one here on the panel is going to shy away from a hard question, but also keep in mind that we are Aggie attorneys, and so we want to show Aggie hospitality to both sides of the aisle, so to speak. We know that one of the things that we're learning as we are attorneys is that we are supposed to fervently hold our position and argue for our position, but we also know from the Texas Lawyer Creed that we need to do that with an amount of civility. And so the really cool stuff is you can ask a hard question without being hostile. So just kind of keep that in mind as you're jotting your questions down to yourself for our Q&A at the tail end.
Can I start? Thank you so much. Thank you so much to Heather. Thank you. It is so great to go to a law school I can drive to. This is actually very convenient. From Houston, I have to fly everywhere, but for Dallas, I can actually drive. Professor Holland, I'm so grateful you came today, and Heather for having me. So Heather mentioned that I am, in fact, the lawyer for that guy you probably heard of on TV. So let me give you the backdrop of the story. It's very often said that legal scholarship and stuff you're about in law school doesn't matter. Not true. In 2014, I wrote a law review article where I explained that 3D printed guns are protected by both the First and the Second Amendment. And I didn't think much of it. I write lots of articles that no one reads, except Cody Wilson read my article. And a couple years earlier, he had put on the internet the files that could be used to 3D print a single-shot pistol, the Liberator. And he actually said, I want you to be my lawyer. I'm like, whoa, I'm just a law professor, but he actually hired me from this. And I've been working on his case now for the last, 3 or 4 years. We lost the district court. We had divided opinion in the Fifth Circuit. We had 5 votes dissenting en banc. We missed the Fifth Circuit en banc. We went to the Supreme Court, cert denied. Went back to the district court. We reached a settlement with the government. So far, so good. But then things got very messy, which is what happened the last month or so. So here's the long and short of it. The government agreed to enter into a settlement with us, where they would allow us to publish these files. And this wasn't surprising. The government had a very narrow escape at the Fifth Circuit last time. It wasn't looking too hot for them otherwise. And also, we were back on the merits. This was no longer a preliminary injunction. So we were about to settle on a Friday, and here's what happened. On a Wednesday, a number of gun control groups filed an emergency motion to intervene. Their goal is to try and block our settlement. They sought a temporary restraining order to prevent the government from voluntarily giving us our license. So we had to scramble. And in the span of basically 12 hours, I stayed up all night. My colleagues and I wrote a brief, no time at all. We wrote a brief overnight responding to this motion to intervene. The next day, the judge had arguments on the phone. He said, you know what, come down to Austin tomorrow. So I drove to Austin. Actually, I flew. It was very early, but I get to Austin pretty early on. And I argued the first temporary restraining order. And I actually won. We prevailed. I was actually able to beat the TRO, and the court allowed the settlement to go into effect. Yay, right? So far, so good. Not done yet. That evening, a couple hours after the court issued its ruling, the government gave us our license. So Cody puts these files on the internet, into the public domain. Didn't publicize that he did, but he put them online. And then we had an idea. We had gotten some cease and desist letters from various state attorneys general from New Jersey saying, we're going to sue you if you put these files online. Well, we already put them online, so we kind of beat them to the punch. But then we sued them proactively. We sued them under Section 1983 for violation of our civil rights. We sued them on Sunday afternoon. And we thought, okay, we'll get ahead of them Sunday afternoon. We expected they'd sue us on Monday. We filed on Sunday, first to file, right? Great. Sunday, as we were filing, we got hit with another motion for temporary restraining order. The Pennsylvania Attorney General said, stop. Don't put these files on the internet. We want an ex parte TRO. I called the lawyer up and said, hey, the files are already online. He's like, what do you mean they're online? Yeah, they've been online since Friday. Downloaded thousands of times. You didn't do your homework. Told it to the judge. Okay? The judge then hosts a temporary restraining order phone call, a teleconference. I took it from the United Lounge at LaGuardia Airport. I was at the airport. So when a judge says, get on the phone now, it doesn't matter where you are. You get on the damn phone. So I was sitting there in an airport, LaGuardia Airport, probably the most noisy airport in the United States, sitting there, and I took this argument. I was making arguments on the phone. And I told the judge, look, Judge, these files are online, but here's what we'll do. We will block any IP addresses from Pennsylvania, so that way Pennsylvania people can't get these files. And the judge, all right, that's fine. So he denied the temporary restraining order. Okay? Again, still, so far, so good. That was Sunday night. We get to Monday morning. Monday afternoon, I get a phone call from the Washington Attorney General. He says, do you represent Cody Wilson? Yeah, I do. Okay, we're about to sue you. Do you accept service of process? I said, well, what's the basis of the suit? We can't tell you. But will you accept service of process for your client? I'm like, do I have a choice? So I was like, yeah, sure, whatever. About an hour later, 9 states, including the District of Columbia, sued us in federal court in Washington. And they argued that the government violated federal law by giving us this license. And about an hour before that, we were sued again by the New Jersey Attorney General in New Jersey State Court, seeking a TRO to stop us from putting the files online, even though the files have been online for 3 days at that point. So sensing a pattern, right? So in the span of 5 days, I had to argue 4 temporary restraining motions. 4 TROs in 5 days. I had to brief all that too. It's insane. I billed 90 hours in 5 days. So fortunately, it was our summer break. It's the only I could have done this. But we had to litigate this. So I argued in Seattle by phone, in New Jersey by phone, and Pennsylvania by phone. I'm just sitting there, and actually the judge says all rise. I'm sitting in my office, and I stand up, and I sit down, whatever. But it didn't work. The judge in New Jersey, I told him, look, judge, we'll block the IP address. I said, fine. He denied the TRO. So I beat 3. But then the 4th one was a Seattle case. And a judge in Seattle, Washington, entered a nationwide temporary restraining order preventing the government from giving us this license. As a result, the files that were already online had to be taken down. Cody removed the files immediately from the internet. He stopped speaking. And that's the basis of the case. Now, we're still here, and there are litigation, there's challenges all over the country. This is nowhere even close to being done. But the litigation implicates very basic constitutional issues. First Amendment and the Second Amendment. Can the government tell someone to take a file off the internet? Is that silencing them? Is that censoring them? Or is that permissible? That's the basis of my talk. Every time I give this talk, it gets longer and longer. It's getting sued in more states. Now it's up to 20 states that have sued us in Washington. They all kind of piled on like the Matrix. They just pile on top of Cody. It doesn't even matter. But we're good. We're on offense. We're moving along. I think we'll wind up in a good spot. So let's take a step back, right, and talk about 3D printing. Who here has ever actually used a 3D printer? What have you printed?
What did I print?
Yeah.
Sunglasses clip.
Sunglasses clip. Professor Holland, what did you print?
Patriots logo.
Patriots logo. Oh my God. Is it like a Spygate thing or no? What was that?
No. I just love the Patriots.
Yeah. Wait, anyone else? Anyone print a gun? Usually no hands go up for that. So 3D printing is based on a system called CAD, computer-aided design. CAD is a way of representing items in 3 dimensions on a computer. You can do something like a car or even an entire house. And this is not very difficult. You may have studied coding in school at some point. This is a very easy item to develop. It involves basic geometry. So if you remember, way back in high school, a cylinder, right, basically a tube. How do you figure out the area of a cylinder? You figure out pi r squared, the area of the circle, times the height. Right? So if I tell you the radius of a circle and the height of the cylinder, I can make an object. So if I say a cylinder with a height of 20 inches and a radius of 5, you know exactly the size and shape of that object, and you can create it. Now, if I gave you a piece of clay and said, give me a cylinder of 5 inches and 20, you couldn't do it, right? If I gave you stone, like Michelangelo's, a chisel, a cylinder, forget it. If I gave you a 3D printer, you can do it in 5 minutes. 3D printing allows you to design things in your mind on a screen, and then it creates it in real life. In realistic, oh, sunglasses, right? That's what you made. You made sunglasses, right?
No, clip.
Oh, come on, close enough, right? You make various items. And the way a 3D printer works is sort of like a candle, right? Has anyone made a candle before, right? You know how this works, right? You take a wick and you dip in the wax and you lift it out. You take it, dip it, dip it, dip it, right? And every time you dip it, it gets a little bit thicker around the base, right? And by the time you're done, you have a full-fledged candle. And you can use different colors, different shapes, different sizes. 3D printing works in the same fashion, but instead of dipping, you have this little nozzle. See this little nozzle here? And it sprays a very thin layer of plastic, one on top of the other, on top of the other, on top of the other. You can see a little bit here. And the base is what's called a heated bed. That way, when you spray the plastic on it, it solidifies right away, so you can build an object. I want to show you now a demonstration of how 3D printers work. This is going to be printing an object. When you see what the object that's being printed is, I want you to shout it out, okay? So, step one. The first layer, they put down sort of a honeycomb lattice. It's a very strong support, right? So this is the first step. Second. Third. See, it keeps getting a little bit taller and taller. Fourth. Anyone see it yet? Fifth. What?
Frog.
A frog, close. So you're actually in the ballpark. Anyone? You're actually pretty close. You're in the ballpark. You're in the ballpark. Getting further. Next. Anyone see it? Oh. You're close. Next you're going to see it. Oh, come on. This one's easy. Oh, come on, Aggies. You're really close to the horned frog. Come on, next. Oh, man. Yoda! Of course it's Yoda. Come on, look. Come on, go back.
There is no try.
There is no print, right? Do you see it now? You see it now? It's Yoda from Star Wars. Ah. The force in you is, no, the weak is a force in you, or whatever. Right? There it is, right? So you can create some pretty sophisticated objects in very short time. This maybe took me less than an hour to print. Okay? Now, because we're in America, and God bless Texas, what do people want to print? Yodas? No, they want to print guns. Which brings me to the Liberator. Now, earlier I showed you the 3D code to make a cylinder. Now, if you think about a gun, one of the most important parts is the barrel. What is a barrel but a cylinder, right? I actually just showed you guys how to make a gun. You didn't even realize it, but I showed you how to make the code to create the barrel of a gun. Now, if you print that cylinder, it's not going to be very good. The plastic used in 3D printing is very brittle. It's not very strong. And in order to actually make a 3D printed gun, you have to make something strong enough to withstand the combustion, which is what Cody did. In 2011, Cody was a law student at UT Austin, the other law school in that state. You go, psst, right? No, you don't like that one, right? Yeah. And he found a way to actually develop plastic that was strong enough to become parts of a firearm. So he printed a AR-15 lower receiver. He was able to print a magazine for an AR-15. You can see it over here. He called it he had another part called the Dirty Diane, named after Senator Feinstein. Right, so he has a lot of different parts, right? This was called the Cuomo, because Governor Cuomo tried banning them. So he had a sense of humor. But he was able to build all these various parts. But what really put him on the map was this. What the hell is that, right? These are the parts to form the Liberator. The most important of which is this right here. That's the barrel, the cylinder. That's actually the thing the bullet comes out of. Now, in order to make the barrel strong enough, you have to actually treat the plastic with an acetone bath, right? You have to basically bathe it in acetone, like nail polish remover, to strengthen the plastic enough so it won't combust when you fire a bullet. Now, they're called plastic guns, but they have a very important piece of metal, a bullet, right? A gun without a bullet is a paperweight, right? So you need the bullet. Also, there's a nail. The nail is called the firing pin. That's actually what triggers the explosion. And every gun needs a firing pin. So these are, yes, they're undetectable. If you take out the bullet and the firing pin, they're also basically worthless. Anyway, what are these squiggly things? These are the springs used to create the pushback to puncture the fire. So here's what it looks like assembled. And here's Cody testing it. If you notice, there's a little sort of rope on the floor. The reason why is in the early days, it wasn't safe to pull the trigger yourself, so you put a string on the trigger and take a few steps back and sort of yank it just to be safe. But eventually, he figured out the technology and was able to perfect the craft. So this was Cody in 2012, or actually late 2011. Now, is there any problem, right? Did he break any laws? Did he do anything improper by making a 3D printed gun? So the first thing to discuss is 3D printing guns doesn't work like this, right? It's not like you push a button and a printer pops out. It's a very involved process that involves a lot of thought, how you structure the files, how you assemble them, how you put things together. There's a lot of mental intervention that goes in. You don't just point, click, and shoot. The second thing I want to discuss is that making your own guns is not new. Who here knows what a zip gun is? Anyone? What's a zip gun?
It's like a piece of pipe with a spring and a firing pin.
It's a homemade gun, right? Believe it or not, again, I come from New York City. I grew up in Staten Island. I did not touch a gun until I was almost 21 years old. My parents didn't let me have toy guns, which explains a lot. I knew nothing about guns, so I take for granted what I know now. But you may not know this. It's very easy to make a firearm. Very easy. For example, gun, soldering iron, garden hose. I can go down to Home Depot and buy $20 worth of parts, and I can make a gun in about an hour. That's a hell of a lot stronger than anything you can make on a 3D printer. So this fear of people making their own guns is based on ignorance of how to make your own guns with easy stuff, right? Not printing. Go to Home Depot, buy a garden hose and a soldering iron. That's a hell of a lot more effective than a plastic gun. Or buy a PVC pipe, plastic, not detectable. If you buy a PVC pipe and a block of wood, you can make a gun. It's not hard, all undetectable. This one looks like a little keychain flashlight. It's a little gun. You can make a gun out of basically anything. And I'm going to show you a demonstration now. Do not try this at home. I know people always say that, but I mean that. These guys are idiots. Don't try this. I'm going to show you this video. See that? The flip phone camera. This is legit, right? These guys made a shotgun out of a piece of rubber tubing, undetectable, a single shotgun shell, which may not even have enough metal to trigger. I'm not sure. It depends how it's manufactured. And a pipe, right? Rubber tube, shotgun shell, pipe to make a gun. How? On the tip of this pipe is a little metal dimple. If you slam a metal pipe into the back of a shotgun shell, it punctures it. And there's a little gunpowder. And when you puncture the gunpowder, it goes boom, and the projectile goes forward. That's how you fire a gun. You pierce the back of a bullet. Right? You understand? So these guys have an idea. They're going to load a shotgun shell into this tube, and they're going to jam the pipe into the tube to explode it. Now, who here sees the problem with this situation? Why is this problematic? What? Yeah. Recoil. Okay, what else? What's else problematic about this?
His hands over the barrel.
Okay, his hands are inches from where the explosion. There's an even bigger problem, right?
The bullet is sitting there. It's going to blow itself out of the back.
And what else? Where are these guys shooting? Inside. Inside. But they're not just shooting inside. Look at what they're shooting at. Do you see this in the corner, this little yellow thing? Let me give you a better shot. They are firing into an outlet plugged into a fan. And if you see, there are 4 or 5 bullet holes, like Swiss cheese, right? There are bullet holes on this box. They've done this before. So again, please don't try this at home, my friends. Don't try this at home. So what happens? Ready? He's going to jam it. Ready? 1, 2, 3. Boom. Okay, he didn't die. Right? He's still alive. Right? And he made a gun with nothing. Parts for $5 from Depot. He's all proud. He's smoking caps, right? These guys are idiots, but they illustrate a point. Idiots can make guns very easily. Very easily. And guns that are a hell of a lot more effective than anything Cody makes with his 3D printer. Undisputable fact. So the paranoia about 3D printed guns is largely undeserved. I think it reflects people just don't know how guns work. If you know how guns work, it's like, okay, you can spend $50,000 on a 3D printer and make your own plastic gun that'll probably work once or twice, or you go to Home Depot for $5 and buy a rubber gun. I go to Home Depot, it's probably a little bit easier. Okay, but that's the state of technology. Now, did these idiots in the garage, I think it's a garage, break the law? No, they didn't. Our good friends at ATF, right, the Alcohol, Tobacco, and Firearms Bureau, said, so long as you're not selling a firearm, you can make it for yourself. There are limits on machine guns, which are not relevant here, but most weapons below 50 caliber, for example, right, you can make it for your own use at home as long as you don't sell it. If you sell it, then you're in trouble, but you can use it for your own personal uses. So then, why did Cody get in trouble? This is not well known. There's no federal law that prohibits 3D printing firearms. There's a federal law that says you can't have a firearm that's undetectable in a metal detector, but you can make your own gun if you wish. Where Cody got in trouble is for putting the files on the internet. And according to the government, when you put a file on the internet, you are breaking the law. Wait a minute. When you put information on the internet, you are breaking the law. How can that be? So we talk about the First Amendment, right? The basic bedrock principle of our First Amendment is that the government cannot impose a prior restraint on speech. They can't stop you from speaking. They can punish you after the fact for what you said. For example, if there's a libel or defamation action, right? You can be punished for engaging in a defamatory act. But they can't stop you from speaking in the first place. If you publish classified information, they can bring charges against you under what's called the Espionage Act, right? They can bring charges, but they can't stop you from publishing it. And the most famous case that's been in the news recently was the Pentagon Papers case. In this decision, the New York Times and the Washington Post. But did you know the movie Washington Post? You ever see that movie? It should have been called the New York Times. I don't get it. The New York Times was the leading plaintiff. The Washington Post kind of backed up or whatever. So in this situation, the New York Times and the Post published the Pentagon Papers. These were highly classified documents about our wars in Southeast Asia. Very controversial. And the federal government ran to court in New York and D.C. saying we need an order to stop the publication of these newspapers. Again, the papers were already out. They wanted to stop the publication of these newspapers. And the Supreme Court said unanimously, no. You cannot stop the spread of information, even if it implicates national security. You can prosecute them for perhaps violating espionage laws, but you can't stop the publication. And this is a case I think was correctly decided. Most people think it was correctly decided. If it involves, information about troop movements, everyone's on the same page. When it comes to printing guns, we say, well, no, guns are icky. I don't like guns so much. But we have history here, right? Who here knows what the Anarchist Cookbook is? Yeah, anyone have a copy? None of you? I see a few hands, maybe. This was a book of how to be a terrorist, right? That basically, it tells you how to make bombs, how to make poison, how to kidnap. I mean, there's some really bad stuff in this book. And if you follow the instructions in this book, you can be a pretty bad person, right? And there were efforts in the 60s and 70s to ban this book from bookshelves. Before there was Kindle, there were actually these things, put books inside, right? Bookshelves, right? They wanted to ban books. And the court said, you can't ban books. That's insane. Cody's information is not in a book, although it actually is. There's actually a guy who had a book on Amazon. I bought a copy where they put Cody's code into a book. It's about 300 pages long. And Amazon actually stopped selling the book. A book, right? A book. Can you ban a book? But you can say, wait, no, Josh, but this is not books. This is code. Well, let me tell you something, my friends. Information is speech. And this is an area where the court has actually been fairly progressive on. The court hasn't hesitated in extending First Amendment doctrine to electronic formats. In a case called Sorrell versus IMS Health from 2011, the court said that the creation and dissemination of information, not just creating it, but also sharing it, right? Retweeting it, if you will. The dissemination of information is speech. And I take this case very seriously, that the mere fact that you're using code to disseminate speech doesn't render it not protected. We live in a world where speech is often done on a computer. I can't draw for anything, but I can use Photoshop, right? I can't make a cylinder with clay, but I can use CAD. And if you use these various tools, you can exchange information. And Cody's plans aren't just used for making guns. They've been displayed at museums. There have been art exhibitions about his code. It's actually it's a work of art, the way he designed it. It's actually quite beautiful. It's never been done before. People study this in architecture, right? There's a lot of expressive value in these files. Let me tell you something. Most of the people who download these files will never print the guns. They do it as a curiosity. They want to learn. They want to find. They want to navigate, manipulate the gun, change things around. These are engaging documents. These aren't some sort of point-click shoot. That's not what we're dealing with here. I promise you not just one amendment, but two amendments. The Second Amendment, I think, here is also implicated. We know that the Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And in 2008, in D.C. v. Heller, the court held that the Second Amendment protects an individual right to keep and bear arms. And a couple of years later, they said the Second Amendment applies to the states in McDonald v. Chicago. Now, what does the Second Amendment have to do with plastic guns? Well, I think it's an argument that the Second Amendment includes a right to acquire arms. Why? What if the government passed a law saying you can have a gun, but you can't sell it, right? There's no sale of firearms. We can have it if you already got one. If you can't acquire a firearm, the right doesn't have much meaning. Now, does that mean they can't be regulated? Of course, you can regulate the sale. But there's a basic right to acquire guns. But even stronger than the right to acquire guns is the right to make your own arms. And this is one I'm actually far more certain about. Long before there was Walmart and Cabela's and other stores, if you wanted a gun, what did you do? You made it. And to this day, we still have the tradition of people making their own firearms. You can make your own zip gun in your garage like those idiots. Perfectly lawful. But wait, what's the government actually doing here? They're telling Cody that he can't speak about the right to keep and bear arms. This is what's called a hybrid right. For example, the government passes a law saying you can't wish someone Merry Christmas, right? The fake law that doesn't exist, right? The war on Christmas. You cannot wish someone a Merry Christmas. Is that a violation of free speech or free exercise of religion? Or both? I think both. So here, Cody and others are being censored about how to make firearms. Okay, so let me wrap up and talk about what laws are on the books. One law in the book now is called the Undetectable Firearms Act. This was passed in 1988 to prevent plastic firearms. Wait a minute, Josh. Congress in 1988 tried to ban plastic guns? Yeah, this is not new. 30 years ago. You probably weren't even born in 1988, a lot of you, right? Why did they try to ban plastic firearms in 1988 when it wasn't really a thing? Because of the Glock handgun. Anyone know about the Glock handgun? Okay, it's a very popular handgun. But the real culprit is Bruce Willis. John McClane in the greatest Christmas movie of all time, Die Hard. Don't at me, right? So there was one scene in the Die Hard movie where Bruce Willis goes, I'm going to read it to you. Luggage, that punk pulled a Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up in your airport X-ray machines here, and it costs more than what you make in a month. Every single sentence, every single thing in that sentence is false. Every word of it, right? There is no Glock 7. That model doesn't exist. It's not made of porcelain, it's made of metal. It's made in Austria, not in Germany. It will show up in an X-ray machine, and they're fairly affordable. So Congress legislates against phantom guns in Die Hard movies, right? That's what Congress does. But this is not a new problem, right? The idea of making plastic guns is not new. And perhaps it's easier now, but this is not a new problem. Okay? So we have this law in the books, and the Liberator complies with it. There's metal involved in the gun. All right? Now there were efforts to try to ban 3D printed guns. Those efforts went nowhere in court, or in Congress. Some states have actually now started to prohibit 3D printed guns. We'll get there eventually. Then you have materials. Let's ban plastic. No, you can't ban the plastic. Why? Because you can 3D print metal, like Terminator, right? You can 3D print a metal gun, which I guess defeats the purpose because then it's detectable, but you can make a metal gun with a 3D printer. I mean, just about anything. So this is where we come to export control. And this is how the government got Cody. The government said, by putting a file on the internet, you are engaging in arms export. Huh? If I mail a Stinger missile to Afghanistan, arms export, guilty, right? Guilty is charged. But if I put a file on the internet, how is that an export? Because non-US citizens can access the files. Here's the craziest part. If Cody mails the files to people on a thumb drive, if he puts the files on a USB drive and goes to the post office and puts it in an envelope, he's broken no law. In fact, he's done that. He's actually now sending people thumb drives. Thank you, Washington, right? He wants to give away for free, but it can't, so he's selling them. Okay, good. The government says you can put these files on a thumb drive, but you can't share them on the internet because foreigners may find it. This is an argument I do not think will prevail on the day. It's completely irrational. With strict scrutiny, you have a very high burden. And to the extent that this is speech, I think the courts will not accept this. But let me wind down my last slide, and I'll turn it over to Professor Holland, patiently waiting. There are serious issues here. And I get people don't like guns. I do understand this. My parents are lifelong Democrats. They hate everything to do with guns, but they still love me. But they always say, Josh, why are you representing this guy? Why are you doing this? And my response is fairly straightforward. In American history, the people who defend and fight for rights are always outside the mainstream. People who burn flags, people who protest at military funerals, right? There were the communists, there were the anarchists back in the early days with Gitlow and others, right? Sacco and Vanzetti, right? The people who wind up in Supreme Court cases are not your average folk. They're there to challenge norms. And I see in Cody someone who's fighting for principles that I value. I don't agree with everything he does, but not by a long shot. I find a lot of what he says pretty silly. But I believe firmly that he's fighting for a value of free speech on the internet, which I believe in a lot. And just think about this case, right? If the government can censor 3D printed gun files, what other files can they start to censor on the internet, right? Do we want to give the state the power to throw people in jail for putting files online that are in the public domain, right? And I offer this example, right? Let's say we're living in a different time, and we still have morality, And let's say someone figured a way to 3D print a sex toy, and the government said, no, we cannot have people 3D printing sex toys because these things are immoral. And it's against the law to have sex toys. We're going to ban putting sex toy files on the internet. The ACLU will be all over that in 5 seconds, right? But when it comes to guns, like, oh no, guns are bad. Okay, it's legal to make your own gun. Perfectly legal to make your own firearm in all 50 states. Right? It's not a crime. If you're prohibited from making a firearm, you're banned. You can't do it. But what the government can't do is stop people from sharing information about firearms. I think that's where the case runs awry. I will stop here, turn it over to Professor Holland, and I welcome your questions later. Thank you so much. Sorry. That's right.
I'd like to start by urging you all to vote Vishnabhat for 1L SBA rep. Vishnabhat, I believe. Sorry, I have a. It doesn't work at all. That's all right. Okay, so unlike Josh, I haven't been in this litigation from. I should check my time here. Okay. I haven't been in this litigation from the beginning, so I'm coming to this a little late. So I pardon if I'm doing a little more reading from my notes, but I really am sort of bringing general principles to a very specific topic. So first of all, thanks, Josh, for coming. We really appreciate it. Let me start by disposing of 2 issues, which are pertinent to the defense distributed case, but I don't think are really why anyone is in this room. The first is that I believe that the Washington Federal District Court was correct to issue to both the TRO and the preliminary injunction, but not necessarily because of the actions of defense distributed. It's clear to me instead that the settlement agreement entered into by the State Department was an arbitrary and capricious decision. They did it suddenly. They did it without adequate procedure or explanation. They modified the list of munitions to allow for the distribution of the Liberator CAD files. That violated, in my view, the APA, the Administrator's Procedure Act. I know this is a boring point to make, but I think it's important to understand where the case is and why that was entered. That's the basis of the TRO. Okay. Now, of course, in a TRO, you are talking about the merits of the case also, so I'm not saying it's not there. I'm just saying that procedurally, it's really that's where this is. Similarly, I agree with Josh that export controls are really not a useful vehicle for addressing the key constitutional issues at stake here. The regulations are very complex, and we really are in danger of just entering into the abyss of administrative procedure and law. So for clarity's sake, for this discussion, I'm going to change the hypo. You guys aren't allowed to do it, but I'm a professor, so I can do it. So I'm going to change the hypo a little bit just to make it simple, okay? And so we can get to the meat of the arguments, which are the First and Second Amendments. So here's my really simple hypo. First, in my hypo, we're going to presume that the possession of a 3D printed plastic gun has been made illegal, okay? Just so we can clear up that the end user of the file, if they possess the gun, would be committing a crime, okay? Second, I'm going to posit that under my scenario, federal law prohibits the distribution of the CAD files that could be used to produce the parts of the gun. So we're setting up the same scenario just with a little clearer. The end user can't possess it, right, under the law, at least assertedly under the law. And the federal government has said, because they can't possess it, you can't distribute the CAD files. Same basic issues. So the question is whether the law prohibiting the distribution of these CAD files would violate the First and or the Second Amendments. Does that make sense to everybody? Okay. So in hopes of getting to the heart of the question, I'm going to do something I don't often do. I'm going to concede the following. So first, I'm going to concede that the instructions on how to build a variety of weapons, including guns and explosive devices, have been available in book form for decades and are now fairly readily available online. So they're out there. Second, I'm going to concede that the CAD files that could be used to produce the parts for the gun using a 3D printer are available online from multiple sources, not just some defense distributor. And third, and this is probably one of the big ones, I'm going to concede that the gun itself, that the digital information such as the CAD files is a form of expression within the meaning of the First Amendment, at least in the abstract. So the First Amendment, I would agree, applies. I would not concede, and this is important to the argument, that the gun itself that is produced using the CAD files is a form of expression protected by the First Amendment, merely that the CAD files themselves are. People might disagree on that, but for the purposes of our discussion, I'll accept that. And then finally, I will concede for purposes of this discussion that Professor Blackman is correct that under the Second Amendment, individuals have a right to keep and bear arms, to acquire arms, and to make arms. I've conceded a lot, right? No.
He's going to change course real quick.
Real quick. In fact, the next word in red and underlined is but. I would not concede that these rights, particularly the Second Amendment rights, are as fundamental as Professor Blackman asserts. And I will return to this, but in brief, Justice Scalia, who we spoke of earlier, made the point clearly.
Hallowed be his name.
Huh?
Hallowed be his name.
Hallowed be his name.
A Jones Day alum, by the way.
Yes, indeed. I still claim him. Justice Scalia made the point in Heller that recognizing a relatively narrow right and expressly reaffirming the constitutionality of government restrictions on certain kinds of munitions. This included, for purposes important to the purposes of this conversation, certain modifications. What Professor Blackman might refer to as the making of arms, certain modifications, and in particular, one of the examples he gave was the creation of a sawed-off shotgun, which he reaffirmed could be prohibited. So this brings me to my first point regarding the Second Amendment. I realize this was pretty stupid after I wrote it. My first point is about the Second Amendment, and my second point is about the First Amendment, but bear with me. So, in his Tennessee Law Review article, which became the basis for this litigation, I understand Professor Blackman, as I understand Professor Blackman, I believe he overstates the scope of the individual Second Amendment rights, at least as recognized by Justice Scalia and his colleagues on the court. Justice Scalia wrote in Heller that the Second Amendment, quote, protects commonly used and popular handguns, at least as against a ban. That's a pretty narrow ruling. He also ruled that the Second Amendment does not prohibit the regulation of atypical arms or arms generally used for unlawful purposes, including, for instance, the sawed-off shotgun. In fact, if you look at the history following Heller, several lawsuits followed, including multiple lawsuits by Heller himself. He challenged the firearms registration procedures put in by DC, the prohibition on assault weapons, the prohibition on large capacity ammunition feeding devices, and all of those restrictions based on Heller were upheld. Okay? Moreover, Justice Scalia recognized that the government can regulate all the way to the point of prohibition. The selling, the selling to, the acquisition by, and the possession of guns by certain classes of at-risk or potentially dangerous persons. So I've now talked about both classes of munitions and classes of people recognized in Heller. It seems to me that the Liberator, which is the end product which, and this is, I'm going to use a very important word here, defense distributed intends for the CAD files to produce, right? Of course, there's some raw materials and assembly required, but that defense distributed intends for them to produce would be just the kind of atypical weapon that might be regulated under Justice Scalia's Heller decision. In fact, I would go a step further. I believe there is also a very good argument, I'm not quite as sure on this one, but very good argument, that 3D printed plastic guns may be presumed to be arms generally used for unlawful purposes, at least from the view of the government's background and the background of what I can glean from the legislative background. So, to stick with my earlier example, not everyone who makes a sawed-off shotgun does so for the purposes of committing a crime, but a significant number do. And therefore, the government can regulate them. In fact, it can prohibit them. Okay? But that brings me to the second point, because of course defense distributed is not actually distributing the gun itself. If it was, the fact that the government has the power to regulate both the types of weapons and the people who receive them, that would be a much easier argument. What they're distributing is the CAD files that are used to produce the parts themselves. The instructions, and I do know that they are, I want to note they are machine instructions, but they are instructions on how to make the gun itself. So that brings me to the First Amendment. In essence, as I understand Professor Blackman's argument, he's arguing that the CAD files are a content-based restriction on speech. And he notes correctly that such content-based restrictions are generally subject to the strictest scrutiny, which the government never wins. Right? And that's where it gets really interesting to me, because I don't think that this is a settled question either way, but I am actually inclined to agree with Professor Blackman.
I'll take one F too.
Yeah. That this is content-based, and that it would be, under normal circumstances, subject to strict scrutiny. But there are exceptions to this, right? So this is where I'm going to get to sort of the core of the First Amendment argument. I fear that Professor Blackman is walking into a trap of sorts on the First Amendment issue. Maybe a blind spot on the First Amendment issue. And it's a trap that's been simmering for some time, as I will argue. And it has the potential to significantly curtail First Amendment protections for what I would call instructional speech, or speech that serves a teaching function. Okay? Because I do believe that these CAD files can be characterized as such, particularly instructional speech. So, all the way back in 2005, believe it or not, the first article I ever wrote as a law professor was entitled, it's a ridiculously long title, but it summarizes it. Inherently Dangerous, the potential for an internet-specific standard restricting speech that performs a teaching function.
Ooh, you were ahead of the curve.
Look at that. Yeah, if only they'd known that then. I'm like all those dead artists. So there were three threads to the story of how I ended up writing this. The first one was the passage of 18 U.S.C. 842p, which prohibited the teaching or demonstration of how to make an explosive device, a weapon of mass destruction, and so forth. This was proposed by Dirty Diana?
Dirty Diana.
Diana Feinstein, Diana Feinstein, right after the Murrow building bombing in Oklahoma City, and then it languished until the Columbine shooting, where the shooters used improvised explosive devices, and it was then passed. Okay, the FBI and DOJ did not want to prosecute under that statute, but after much urging, they did, and they undertook their first prosecution in 2002, just 3 years later, of Sherman Austin, who was a teenager living in LA, an avowed anarchist, although not a terribly effective one, who had posted online rudimentary, instructions on how to make rudimentary explosive devices, such as a Drano bomb, things like that. These were basically things from the anarchist cookbook, right? And the third thing, so we have the bomb making statute, and we have the prosecution of Sherman Austin. Then we had the prosecution of a guy named Jerry Dean McCoy, which reached the court in 2002. And Jerry Dean McCoy was arrested and charged for being at a barbecue. He was kind of like the old school gang member. And he was at a barbecue, and he started talking to some of the younger guys, and he started telling stories about his gang days, and then started, you know, because this is what we do when we get old, telling them how they should run things. And he was arrested for instructing a gang how to be a gang. And it made it all the way to the Supreme Court. For a variety of reasons, cert was denied. But Justice Stevens wrote what he called a statement respecting the denial of certiorari. Okay? Very unusual. So, as short as I can, I'm going to sort of walk through the trap that I see potentially for this. Go back to Brandenburg, which I hope that most of you are familiar with, which is the idea that, well, actually, I'll give it to you real quick. Brandenburg holds that the constitutional guarantees of free speech and free press do not permit the state to forbid or prescribe advocacy of the use of force or of law violation, except where the advocacy is directed at inciting and producing imminent lawless action and is likely to incite or produce such action. This ruling was based on something called the Speech Act doctrine, which allowed for the fact that you might be able to ban such speech where the speech merges with the act of another. I hope you're seeing the connection here, right? But what Brandenburg required was specific intent, imminence, and likelihood. Those three things. What Justice Stevens proposed was that speech that performs an instructional function or a teaching function does not follow the same rule. He argued that if instructional speech has a clear support in public danger, right, that there's clear support in public danger to believe that this instruction could cause public danger, that you can take out the imminence requirement and focus instead on the specific intent and the likelihood, right? Is there such a support for such a position? And the answer might be surprisingly yes. So there's a case out of the Fourth Circuit called Rice versus Paladin. I hate it. That's the truth. I hate it. But it basically allows for suing a publisher of a book of the hand. It was called the I don't remember the exact title, but like the Hitman's Handbook.
Yeah.
And then somebody followed the instructions and indeed killed somebody. And they went after the publisher, and the Fourth Circuit actually allowed that. I'm not going to get into the details of why, but essentially they took the view of what Justice Stevens was talking about, that imminence isn't required when specific intent is there and likelihood is there. You meant to have people kill people, you meant to instruct them, maybe not to have kill people, but you meant to instruct them, and there was a high likelihood and a clear danger about that speech. Another source is aiding and abetting cases, where the court often overlooks the imminence requirement to link speech, instructional speech, as a way of aiding and abetting, and we're seeing that in material support for terrorism cases. But the most important one to me is actually a group of cases, and as far as I know, they are all unanimous. There aren't a lot of them, but I haven't seen any to the contrary, where people are prosecuted for doing nothing more than giving advice on how to evade taxes. And there is no imminence at all. They're at like a seminar. Not a seminar I've seen, but nevertheless, a seminar on how to illegally evade taxes. And it has not required any proof that anyone did any evading of taxes. Merely telling people how to was enough. So what do I think when this is applied, these basic principles are applied on the internet? And I actually wrote against this movement. I don't like this movement, but I do think it's something that you are, that could become a major obstacle in your case. Because when you put things on the internet, and you, instructional speech particularly, and you remove the imminence requirement, all that's left is this intent and likelihood. Well, what have you done? You have literally put something on the internet that you intend people to use to produce something that, under my hypothetical, is illegal. And you've made that available to millions upon millions upon millions of people. And essentially what Justice Stevens has argued, and many others have picked up on recently, is that when you have these widely available instructions, uncontrolled, that essentially proves your intent. And that essentially proves the likelihood. I think that's a trap we're headed towards. I honestly think that's where we're headed. That at some point, the availability of instructions that could lead to what is perceived, rightly or wrongly, as dangerous, they will revise the Brandenburg standard, they will take out the imminence requirement, and they will find that intent and likelihood are satisfied merely by placing certain kinds of instructional materials on the internet itself. Last couple of comments, with all due respect to Josh, I don't think that the fact that this isn't new doesn't matter. I don't think the fact that the files are already out there matters. I think it's entirely irrelevant. Congress isn't required to address all instances of the same thing. They aren't. Just because I murdered somebody doesn't mean you can't get someone else for murder. I just don't see the relevance of that. And I think that the hybrid right has some issues because of how I at least interpret the Heller decision as being a fairly weak decision in favor of 3D plastic guns. So I don't think you necessarily get to, jack one up with the other. I hope that's in some way helpful moving forward. Thank you. I appreciate it.
Do you want to go right to Q&A because we're running a little bit late?
Yeah.
We are running
Yeah,
late.
I'll forfeit my time.
Do you want, just kind of collectively as a group, do we want to do a 5-minute Q&A or do we want to break? And if you have questions, come up and see either Holland or Blackman. Do you have any opinions?
Just go Q&A.
Okay, 5-minute Q&A. Do we have any questions? Yes. Sure.
I might stumble through asking this, but for Professor Holland, what did you say the requirement for likelihood was? Was it generally, usually used as something? Because
I didn't say one because there isn't really one defined. They talk about the fact that it usually has something to do with the fact that not only are you telling someone to commit a violent crime or do something illegal, but that they actually have the ability to do so. So the likelihood would be that they're getting the files. Your intent is that they get the files. Doesn't have to be imminent, right? Your intent is to supply them with the information capable of making the weapon, and that they actually have the ability to make the weapon. But since the government has taken the position that you don't have to point to anyone who actually has made the weapon, just like you don't have to point to someone who's actually used your instructions to evade taxes, the likelihood argument becomes they're widely available.
Right.
It's likely that somebody would.
Because like if you give somebody information on evading taxes, if they use that 100% of the time, it's illegal. Just having the weapon. Not
Is it
necessarily.
your position that publishing a book with tax evasion advice would be illegal?
Legal?
Illegal.
Illegal.
Under this says publishing a
book?
book that says here's how you can evade taxes. Wesley Snipes for Dummies, right?
I think under in the tax evasion area specifically, yes, because they've held so in public forums where you're speaking.
But that's instructions to a person versus a passive book.
Yeah, I think that's the tough one. I mean, that's the distinction, and I think that when they come to the internet, that distinction melts away, because they've said it doesn't have to be a specific person; it just has to be likelihood that they're.
So if I can, I'll respond a little bit. There was a case called Holder versus Humanitarian Law Project about 4 or 5 years ago, and that was a case where members of various civil rights groups were accused of providing material support for terrorists and terrorism overseas. And the court was very stringent on the mens rea requirement, right? It wasn't enough that they knew that they were helping them, that's specifically being to trying to help them. And that got them around the First Amendment. I think the passive versus the active distinction actually makes quite a difference. Merely publishing a book or putting a file on the internet, I think, is different than teaching a class on how to evade tax. I think there's a distinction there. And that's where the imminence may actually come into effect, whether or not it's in play, but the specific intent has to be very precise for the mens rea to work.
I think that works in the context of that statute, because they were accused of trying to help specific people. And I think that's the flag I'm trying to raise, is that when you take away the specific person, I think the inclination would be to believe that the First Amendment protects you.
Yeah.
And what I see in some of these cases and the way that they're being applied is the potential for it doesn't matter that there's a specific person if you have made it widely enough available that is almost certain to help someone. And I think this is sort of the Rice versus Paladin argument, right? Which is the Hitman's Handbook argument. They didn't intend for a specific person to use it. They didn't even really probably intend for anybody to use it, right? But they were still found to have created the danger. I want to make clear that I don't think this is a good thing. I'm just saying that it's something I see coming down the tracks.
We have one more question before the end of time. Yes, ma'am.
So just to follow that, wouldn't you then have to, with that argument, submit to the logic that a firearm is only used to commit a violent act, an illegal violent act? Versus
That was his
a
first concession.
argument?
His first concession was it is illegal by itself. That's why it was a very important concession.
Right. That's I have to in order to get this point. But to your point, I'll give you a big I don't know, but explosives can be used for a lot of things. Most of them not illegal, right? In fact, I know people that blow stuff up for fun. Not saying I ever did that.
It's an idea for a
But I did. You know, the fact that it can be used for other things hasn't seemed to be the dispositive thing. But although Josh raises a really important point, right? Because the tax evasion stuff is aimed at something that is specifically illegal, right? And that's why I gave the consent. I started with the concession or the hypo that's saying possessing the gun would be illegal. But I think your question is a good one. What if it wasn't illegal in all cases, but only certain cases? And we're going to run into that.
Felon in possession, for example.
Felon in possession, right? All the new laws that are being enacted about domestic abusers and things like that, right? So what if sometimes it's illegal, a significant number, and a significant enough number it's illegal, but other times it isn't? And I think that's something that has to be ironed out. My gut tells me they're going to give the government a lot of deference on what they consider to be danger.
So, and one thing to be clear, our case might not be the right case to articulate that. What What Professor Holland is saying is, could you craft a statute that's narrowly tailored enough with a mens rea or a specific intent requirement? The statute we have here has none of those elements, so it doesn't. I don't think.
Export control.
Yeah, I don't think any of the things discussed here actually implicate the case we're litigating. But let's say a state tried to enact a law with that sort of specific intent requirement. That would raise the exact sort of thorny issues that Professor Holland is discussing.
And I feel like that's where your case is headed, because I think the administration has kicked the case, right? And I think the 10 AGs, I think it's 10, right?
It's 20 now, 19.
20.
Well, I don't count DC as a state, so it's 18 plus 1.
Okay, 18 plus 1.
I actually, so this is actually funny. So in our, you file a complaint and you file an answer. They listed DC as a state, and in our answer, say we object to that. It's not a state. I don't think they noticed, but we reject that. We rejected that paragraph that DC is a state.
As you should.
It's not a state. It's not a state.
So I imagine the next thing that these states are going to do, because once they follow the procedure, the feds can change its status.
Hello, Dick Tracy.
Once they change the status, I imagine what you're going to see is states attempting to ban it, and we'll see, or put restrictions on it. I think what's California doing, requiring a serial number?
Well, that's actually complicated. I don't want to get too far into it, but you can actually get a serial number for these sorts of weapons. It's complicated, but you can still get one.
So.
All right.
We
Well,
done?
thanks and gig 'em.